$30,000. That's how much state of Michigan collected child support from a man for 26 years. Interesting part is, he was never the father. Everyone in that courtroom knew it. So why did the judge still order him to pay? Why did the system look away after the proof was sitting right there on the table? That question has an answer, and it is worse than you think. Carnell Alexander's case is documented. Court records, federal filings, state statutes, all of it on paper. All of it is real. Sit with me. I want to show you exactly how this works. This channel is not a law firm. It is rebellion against the evil itself. This is a friend who stayed up until 2 a.m. going through court records so you don't have to, and came back to explain every single thing they found. Every video is built from verified case outcomes, state statutes, and documented public record. No speculation, no agenda. If that is what you have been looking for, the subscribe button is right there. Carnell Alexander grew up in Detroit, 8th grade education, a youthful offense that put him behind bars for a stretch. No resources, no legal connections, just a man trying to build something when the world came looking for him. Normal day in Detroit, routine traffic stop him. When the officer ran his name, something came back that made no sense. There was a warrant, child support, for a child Carnell had never heard of, had never met, had no idea existed. The officer told him he was a deadbeat dad. Carnell told the officer that was impossible. He didn't have any children. And that is where the story gets complicated, because the officer wasn't wrong. The warrant was real. What wasn't real was the ground it was standing on. Back in 1987, an ex-girlfriend had a baby. She wasn't certain who the father was. She applied for government assistance, aid to families with dependent children. The program required her to name the father. The caseworker needed a name. The form needed a name. She put down Carnell Alexander. She said publicly she didn't understand what naming him would trigger. She thought it was paperwork. What she didn't realize, the moment his name went on that form, the state of Michigan had a financial interest in finding Carnell Alexander and making him pay. Michigan's own Family Independence Agency pulled the statewide numbers. 30% of non-marital paternity tests exclude the tested man entirely. 1 in 3, not the father. Read that again, 1 in 3. A process server was dispatched to Carnell's family home in Highland Park with a court summons. That server filed a sworn document, signed, official, submitted, stating Carnell had been personally served and refused to sign. One problem, Carnell Alexander was in prison on that date. Michigan Department of Corrections records confirm it. He could not have refused to sign. He was not there. When Carnell didn't appear for the hearing he didn't know existed, the court entered a default judgment. Carnell Alexander, father by court order. From that moment forward, everything the state could bring against a man who owed child support was pointed at him. When a woman names a man as the father of her child on a welfare application, the state initiates a formal legal process, a paternity action. The named man receives a legal summons, telling him he's been named, a hearing is coming, and he has the right to appear and contest it. If he appears, he can request DNA testing. If the test clears him, the case is dismissed. The system has a correction built in, a door that says, if this is wrong, here is how you walk back through it. That door only opens if you know it's there. Under the Michigan Paternity Act of 1956, a court can enter a full default judgment against a man who doesn't appear, as long as service was allegedly completed. No DNA testing required, no testimony from either party, just the process server's signature on a form. One signature, one person, zero independent verification. That was the entire gate between a man's freedom and a legally binding debt. Once the default judgment is entered, it becomes an order of filiation. That order has teeth. Wages garnished, driver's license suspended, professional licenses pulled, tax refunds intercepted, arrest warrant issued. Every dollar owed from the day the original complaint was filed, stacking as arrears before the man even knows his name is in the system. The whole architecture assumed one thing, that the process server's signature was reliable. Nobody built a verification step. Nobody required a second check. One sworn document and the entire machine followed. Here's the other piece most people never know. Michigan law had a statute of limitations on challenging paternity. 3 years from the child's birth, 1 year from the order of filiation, whichever came later. 3 years. If the summons never reached a man, if the only thing in the file is a false signature, Those 3 years run the same way they would for anyone. The clock doesn't know he never got the notice. The clock just runs. Under federal law, a man has 60 days after a paternity determination to challenge it. 60 days. Many men don't find out about the case before that window closes. When Carnell found out during that 1991 traffic stop, the child was already 4 years old. The window had closed before he ever heard the word paternity. He went to court. He told every judge, every caseworker, every hearing, I am not this child's father. Nobody listened. For years, nobody listened. By 2013, 22 years after that traffic stop, Carnell had finally found the woman. He got a DNA test. The result was not close. Not the biological father. The mother confirmed it publicly, on camera. She told a Detroit reporter, everything is my fault. He shouldn't have to pay anything. I want this to go away for him. He brought the test to court. The court said it didn't matter. He had waited too long. February 2015. Wayne County, 3rd Judicial Circuit Court. Carnell Alexander stands before Judge Kathleen McCarthy. He has the DNA test, the mother's sworn admission, Michigan Department of Corrections records confirming he was incarcerated the day the process server claimed to have served him. He has everything a person needs to walk out of a courtroom free. Judge reviews the evidence. Fraud is acknowledged. Case dismissed. DNA is there. Mother is on record saying she lied. DOC records are there. 20 minutes and it's over. That is what fairness looks like. Judge Kathleen McCarthy looked at Carnell Alexander and told him she was outraged. Not outraged at the fraud, outraged at him. She ruled the motion to set aside parentage had to be filed within 3 years of the child's birth. Carnell had not done that. The fact that he had no way of knowing, the fact that the process server filed a false document, those facts did not move her. The court had paperwork that said served. Served was served. The clock ran. Carnell missed it. $30,000. Pay or go to prison. There are 3 documented layers of deception in this case. Layer 1, the mother named Carnell as the father of a child she knew, or strongly suspected, was not his to receive government assistance. She has publicly acknowledged this on camera. Layer 2, a process server filed a sworn affidavit claiming Carnell was personally served and refused to sign. Michigan DOC records confirm he was incarcerated on that exact date. The affidavit was false. Every order that followed had no legal ground to stand on. Layer 3, and this is the one almost no coverage of this case has ever touched. In October 2015, Michigan finally erased the $30,000 debt. The state's notice claimed Carnell himself had requested the debt be removed in writing. He hadn't. His attorneys documented he never made that request. The state erased the debt, generated paperwork saying Carnell had asked for a favor, and closed the file. Even resolving the fraud came with what his attorneys described as forged government paperwork on top of it.
I will go to jail if I have to because I'm tired of the situation.
The argument was this: enforcing a child support order against a man who was never legally served is a constitutional due process violation. Every garnishment, every warrant, every enforcement action stacked on a foundation the court never had jurisdiction to build. A court that enters an order against someone it never legally notified has no personal jurisdiction over that person. The orders weren't just wrong, they were void, not voidable. Void. One process server, one false signature, and the full enforcement machine of the state of Michigan followed behind it for 26 years, without a single check. Murray Davis, board president of the National Family Justice Association, ran a study specifically on Wayne County, same court, same default paternity mechanism that caught Carnell. He pulled DNA tests on men declared fathers by default. 79%. Almost 4 out of 5 men declared a father by default in Wayne County. Not the biological father. DNA confirmed. Not a fringe outcome. A pattern. And the reason that pattern held year after year is because the incentive structure rewarded closing cases, not getting them right. Under federal TNF rules, states must pursue paternity establishment and child support collection to receive federal funding. The state has a financial reason to attach a name. Case closure is the metric. Accuracy is not. Michigan's own legislature tried. The House unanimously passed 2 paternity fraud relief bills, canceled arrears, terminated obligations for men who could prove they weren't the father. Unanimous, both sides. The bills went to the Senate. They stalled. They died. In Georgia, a man named Carnell Smith, different man, same first name, same trap, founded U.S. Citizens Against Paternity Fraud. He lobbied until Georgia passed a law giving men unlimited time to challenge paternity as long as the case remains open. He testified before Michigan Senate committees. He used the word epidemic. Michigan had the information. The bills died anyway. Then Carnell Alexander's story hit WXYZ TV Detroit in February 2015 and went international. Michigan State Representative Jim Runestad introduced new legislation specifically shaped around what happened to Carnell, the thing the legislature couldn't fix in the abstract. It needed a name, a face, a traffic stop that swallowed 26 years. Johns Hopkins Bloomberg School of Public Health peer-reviewed nearly 10,000 paternity cases from a national database, 28% of men who sought paternity testing. The documented record of cases like Carnell's points to one thing that matters above everything else: the proof of service document. If you or anyone you know has ever received a default judgment in a paternity or child support case, request the full case file, then request the proof of service specifically. Find out how service was allegedly completed, on what date, at what address. Cross-reference that against any verifiable record: employment, travel, medical, incarceration. If service was false, that is a due process violation. Due process violations can unwind judgments that looked final. Nothing in this video is legal advice. Everything here comes from public record, court data, and documented case patterns. If you are in a family court case, work with a licensed family law attorney in your state. Carnell Alexander never got an apology. He got a letter saying his debt was erased, a letter his attorneys say contained false documentation about how it happened. The state of Michigan never admitted it did anything wrong. He founded the Carnell Alexander Foundation. He helps men pay for DNA tests they can't afford because he knows exactly what it costs to go through this without the proof you need. He is still fighting, not for himself. That part is over. For the person who hasn't found out yet, a single sworn signature was all it took. And if you didn't know that before this video, that's exactly why it worked.